Hi, everyone. Thanks for joining us. We're just going to give it a couple of minutes for people to join, and then we will get started. Hey, thanks to everyone who just joined. I think we're just going to give it like another minute or so, and then we can get started. Uh, yeah, anonymous attendee. I sent the slides out about 15 minutes ago. I emailed them to everyone who was registered. If you didn't receive them, and if you send in your email address, I can forward them again real quick. They went to spam. Sorry about that. For everyone else on the call, you may also need to check your spam folder. But glad you found them. Excellent. Uh, Great. I think we can go ahead and get started. There's probably a few people who are still joining, but we're going to start with a little intro to ALRP anyway. So I think it'll be fine. Um, Hi, my name is Shloka Krishnan. I'm the volunteer coordinator at ALRP. Thank you so much to everyone who's joining us today. I'm really excited for this presentation from Courtney McCausland of Catholic Charities East Bay on humanitarian parole with a notice to appear. I think it's going to be a really interesting presentation. So a quick overview of the agenda. I think a lot of people on the call are new to ALRP, which is great. We're going to do a little overview of what we do and how you may be able to get involved. If you're already involved, like also excellent. Sorry to make you sit through this again, but hopefully the love and adoration that you have for ALRP, like it just increases with time and with the number of times you hear about us. Then we'll move into the training. We will have time for Q&A at the end. Feel free to use the Q&A function at any time, and we can also address questions as they arise, whatever works best. This is slightly important. When you exit the Zoom, you will be redirected to a link to submit an evaluation form. Please make sure to submit that evaluation because that's what will prompt me to send out a certificate of attendance for your CLE credit. And that's not automated, so give me like a day or two, but you will receive your certificate of attendance, I promise. Some quick housekeeping. The training is being recorded. Everyone is muted, but again, you can use the Q&A function, and you should, if for some reason that doesn't work, you should also be able to like raise your hand and I can unmute you. Again, please submit the evaluation form. And like I said, everyone should have received the presentation materials. If you didn't, happy to resend. Just again, drop your email in the Q&A and I can forward them to you. So some information about ALRP. We were founded in 1983, which means we are marking our 40th anniversary this year, which is a bit astounding. Our mission is to help people living with HIV or AIDS maintain or improve their health by resolving their legal issues. When we were founded 40 years ago, really what ALRP was doing at that time was essentially like drafting emergency wills for people who were dying very quickly. Thankfully, the landscape has changed since then, but there are still real challenges associated with managing a chronic health condition that can be exacerbated by, stress or housing instability or immigration status, of course. So that's what we are really working to address these days, to help people achieve the stability they need to thrive and improve or maintain their health. We do that in a couple of ways. So first, we have a team of 13 in-house staff attorneys, primarily who are working in housing, but we also have one valiant immigration attorney on staff. And so we do provide legal services in-house. And then additionally, we have a panel of about 500 volunteer attorneys to whom we refer those cases that we aren't best suited to take in-house for in-house representation. And those volunteer attorneys really span the gamut of civil legal services. So anything from credit and bankruptcy to benefits to immigration, of course. And having that like breadth of people to whom we can refer cases is really great in helping meet, the comprehensive legal needs of the people who come to us for services. So just a quick overview of numbers. Since 1983, we've handled over 80,000 legal matters for our clients. These days, about 85% of clients have an income under $30,000. So again, the free and low-cost legal services that our panel attorneys provide is really critical in making a difference. So a quick pitch. Our goal in offering these trainings is twofold. So first, we really are just, hoping to improve the capacity and of attorneys in the Bay Area serving our community. But second is we are hoping to recruit new people to join our panel. So if you're not yet on the panel, I hope you will consider joining. I think many of our panel attorneys will attest that it's a meaningful and positive experience for them. It's also as small or large a commitment as you'd like it to be. So we will always reach out to you and ask if you're able and interested to take on a referral before sending anyone your way. And you always have the opportunity to say no, or of course to say yes. But what we do is we conduct a thorough intake and identify the client's legal need, and do some matchmaking to find an attorney who is a good fit in terms of practice areas, in terms of geography, in terms of language skills. And then if you say, sure, I'll consult with this client, we connect them to you, and you can sort of provide a consultation and decide how to proceed from there. In general, we ask that panel attorneys provide at least 2 consultations a year, but it's really always up to you, and we can sort of tailor the experience to what makes sense. So if that sounds like something you're interested in, it would be really great to have you. We are always looking for more immigration attorneys to serve on our panel, especially for people who can help with clients who are in removal proceedings. Those are always difficult to place referrals for. So even if if 10 people on this call join and take one referral a year, that would be amazing and really helpful, right? So I think that's sort of the end of my pitch, but please get in touch if you're interested. All of our panel attorneys are covered by our malpractice insurance. We can also sort of connect multiple attorneys there are areas in which you would like mentorship or guidance. So I think it's a pretty solid arrangement for everyone involved, and we would love to have you. There's also more information online. That's the end of my little spiel. Thanks for listening. Thanks for everyone who's already involved with us or who's going to be as soon as they get off this call. Our presenter today is Courtney McCausland, who is the managing attorney of the litigation division at Catholic Charities East Bay, where she leads the removal defense and unaccompanied and undocumented minors teams. She is also a lecturer on legal research and writing at UC Berkeley Law, and we are really excited to have her here today. Thanks.
Thank you so much, Sloka. That's a very warm introduction. If I can just sort of tag on to the pitch that's already been given for ALRP, I've been a panel attorney for the last couple of years, and it has been a universally positive experience. They're always very responsive and very willing to help connect clients to resources, and even on the cases where maybe I've consulted with someone but not been able to take the case, we're able to collaborate and make sure that that person gets connected to resources, maybe at another organization, or at least gets on the right track to pursuing what relief they are eligible for. So I just wanted to append that on there. If any of you are on the fence, I would encourage you to take advantage of the opportunity to join the community. It's doing really good work. So with that, I am going to go ahead and share my screen. And once I share my screen, I'm going to go ahead and turn my camera off just for the duration of the presentation as I'm going through the slideshow so that we can all focus on the content of the slideshow. So give me just a minute to pull this up. Okay, and Sloka, are you able to see the PowerPoint now?
I am, yeah.
Thank you. Okay, so humanitarian parole with an NTA, what you and your client need to know. I spent a lot of time thinking about how to frame this topic for today's presentation. And there's a couple of things that I want us to start with. This is an extremely broad topic, and we will not have time to cover everything. So there's a couple of things I'm hoping to accomplish today. The first is to provide both a general overview of the law as it stands, as well as just developing some vocabulary for practitioners to understand what further inquiries need to be made in each client's case. So parole as a function of law in immigration has existed in the statute for decades, but it's really only been in the past decade, and in particular the past couple of years, that parole has been the preferred tool of the executive branch in response to emergent crises. So what that means is that parole continues to be developed and expanded all the time in some very sort of convoluted and nonlinear ways. And that means that some of the points I'm going to talk about today are going to be addressed in a little bit of a nonlinear fashion. So I do ask for your patience as we get through that. Some of you, if you have questions as we go, as Sloka said, please feel free to pop that into the Q&A. And if I'm able to answer it right, then I will. But I may also say, hey, just hold on to your question. We're going to come back to that later. And so it's just really, this structure is in response to the evolving nature of this topic and the realities of the practice area. So let's just briefly touch on an agenda of what we are going to be covering. We're going to start by identifying some of the relevant terms for this topic. We're going to discuss the evolution of the law, and I'm going to really focus on some of the practical elements of what does this mean for talking through this issue with your client. Now, the last thing I want to highlight here at the beginning is that this issue is particularly complex. This is not really what I would qualify as a beginner issue. So if you are early in your career as an immigration practitioner, I would really recommend that you actively seek mentorship on these cases as you get a feel for the landscape of what's going to be included here. So let's start from the beginning. A client comes to your office talking about having been paroled into the United States, and they say, hey, I also have a court date. Where do we even begin with that? So you want to start your inquiry by assessing that person's manner of entry into the United States. So you're consulting with a client about potential options, potential relief that's available to them. Of course, you're evaluating that what forms of relief they're even going to be eligible for. So that threshold question is, how did they get here? How did this person come to be physically present within the United States? And we start by asking that individual, but then of course we also need to review what documents they may have from any encounters with immigration officials. And we're going to touch on that more in just a little bit. But so when we're talking about manner of entry into the United States, we can kind of broadly categorize it in three ways. The first is going to be entry without inspection, and people self-describe this in 100 different ways, right? They might say, I entered without permission, or I crossed on my own, I crossed the river, I crossed through the desert or the hills, I came with a coyote or a smuggler. There's different ways that people will self-describe this, but what that amounts to is an entry into the United States without an inspection by immigration officials. People can also be paroled, and that is going to be the category we're spending the most time talking about today. And then they may also be inspected and admitted on a visa in some sort of visa status. We're not going to talk about that further today, but you can generally think about it in these three categories. So parole. What is parole? Parole is authorized under INA Section 212 D5A as codified in 8 USC 1182 D5A. And the thing to understand about parole is that the INA uses this term, uses parole as a catch-all phrase that authorizes the United States government to allow people to enter the United States who would not otherwise have a means to enter the country with permission. So they use this term very generally, very broadly. And the parole authority under the statute is a broad authority. And the government has exercised this power in different ways to address different groups of people. Sometimes they use it to allow entry, some people to allow departure and re-entry, and for some people, it allows them to remain in the United States. And we'll talk about each of these in a little bit greater detail. When we're talking about parole, thinking about who has the authority to issue this, USCIS, ICE, and CBP all have the authority to authorize parole. Now, parole allows entry to the United States, but I need to qualify that term. When I say entry, there is physical entry as a matter of fact, and there's entry as a function of law. So while all forms of parole allow for the factual physical entry into the United States, they do not all qualify as legal entries to the United States. And because the term parole is used as this catch-all phrase, it can create a lot of confusion, both among immigrants and advocates as to what this really means as a practical matter. So let's clarify the different categories of parole. Parolees are considered applicants for admission to the United States. What are these categories? So we're going to just cover a couple of the most common ones, the ones you're most likely to see in practice. There are other parole categories we're not getting into here, but these are the ones that are going to be most pertinent to the topic of today's presentation. So the first common category of parole under INA Section 212D5 is advanced parole. Advanced parole grants certain individuals permission to leave the United States and then to re-enter the United States under parole to resume an application or status they had prior to departure. So this is for folks who have temporary protected status, if they have a pending application for adjustment of status, DACA recipients, etc. It allows people to leave and return and resume that status they had prior to departure. We also have parole in place. And, scrolled ahead. This grants certain individuals who entered the United States without inspection permission to remain in the US with parole to seek adjustment of status. And this category tends to be unique to family members of current or former military service members. So folks who enter without inspection are then able to remain with a parole, which then enables them to seek adjustment of status. So in practice, what do those documents look like for those two categories? Well, for advanced parole, we would look for Form I-512L being issued by USCIS. That would be the form that would demonstrate the approval, right? And then you would also look to see in someone's passport whether that stamp had been issued at the time of entry by CBP, showing they had been paroled back into the United States. When we're looking at parole in place, we would be looking for a Form I-94 issued by USCIS, and that would provide a record of admission or parole into the United States. That's what that form is used for. The I-94 is a record of admission or parole, and that's the form that would be used specifically to document that someone had received parole in place. Now, those are two common ones, but let's move now into sort of the main crux of our presentation parole topic today, which is, of course, humanitarian parole. So humanitarian parole is a discretionary grant of temporary permission to enter the United States for urgent humanitarian reasons or for significant public benefit. Now, historically, this was applied for by folks who were outside of the United States attempting to enter the United States. But this category keeps getting applied more expansively to address emergent crises. The application process is administered by USCIS's Humanitarian Affairs Branch, but like I mentioned earlier, USCIS, ICE, and CBP all have authority to authorize parole, and so this can get really messy in this topic. When the government is analyzing someone's application, when they're trying to determine whether or not to grant their application for humanitarian parole, they consider three factors. They look first at the level of suffering experienced if parole is not granted. Then they look at time pressure, and then they look at the effect a rejection might have on the applicant's well-being. So, for example, humanitarian parole might routinely be granted for somebody who is in dire need of medical treatment. They need to come into the US for medical treatment. Or maybe they have a family member who's nearing the end of their life, or they are set to provide urgent medical care for someone in the United States. Or maybe they need to enter to attend a funeral or assist in a national disaster relief effort. Those are just some common examples. It's not an exhaustive list. So then, as I mentioned earlier on, the application for humanitarian parole has continued to be expanded. And most recently, we've seen this in the continued development of country-specific programs. We have country-specific programs for the Ukraine, for Afghanistan. There's a new process for Cubans, Haitians, Nicaraguans, and Venezuelans. There's the Cuban Family Reunification Parole Program, and then recently also the Family Reunification Parole Programs for Colombia, Guatemala, Honduras, and El Salvador. So these have also then, beyond the general authority that's found in the statute, this general authority has been used to justify the expansion of these programs into a country-specific context. Beyond that, we have also seen it be expanded to be used as a resolution for the Migrant Protection Protocol. At this point, hopefully all of you are familiar with this program, but if not, I'm just going to go through it briefly here. The Migrant Protection Protocols were abbreviated as MPP. It was also known as the Remain in Mexico program. The MPP program was initiated in 2019. And under this program, asylum seekers were forced to wait in Mexico while pursuing asylum in the United States. Unfortunately, many people were subjected to serious harm that included kidnapping, assault, family separation, and more. And so in January 2021, the Migrant Protection Protocols were terminated by executive order. And then the following month, approximately 20,000 people who had been stranded in Mexico under this program began the process of seeking parole into the United States. Now, thus far, what we've seen with this is that only people with active pending immigration cases are eligible for parole under this program, i.e., not those who were ordered removed or whose cases were never filed with the court. And so what's interesting about this particular situation is that the Department of Homeland Security has acknowledged in its own publications that the MPP program created a lot of danger. And so in the process of winding down their program, it has begun to parole individuals into the United States under this humanitarian parole paradigm. So in practice, what do these documents look like? So if we're looking at humanitarian parole, most commonly what we would be looking for is a form I-94 issued by CBP that provides a record of humanitarian parole into the United States. And you can see here on the screen the little stamp. We've got the I-94 form itself. That's the arrival and departure record, but then we've got specifically that little blue stamp, the parole stamp. But I want to give you a really significant caveat here. So CBP issues a variety of documents to evidence humanitarian parole into the United States beyond the I-94. They don't make this easy for us. So they will issue call-in letters using Form G56, and I have an example of that one here for you in just a second. They'll put parole stamps like the one that's pictured here in passports, on border encounter documents, appointment notices, and more. It is messy. It is messy in application. So this is part of why I sort of give that disclaimer at the beginning that if you are new to this practice area, mentorship is important because it's hard to even know what documents to look for evidence of this. But so you might see this sort of parole stamp, but you might also see a document like this Form G56 call-in letter. And this is a letter issued by DHS telling someone that they had an appointment at 630 Sansom Street in San Francisco with an ICE deportation officer. And you can see there's no parole stamp anywhere on this document, but when you look at the reason for the appointment, it says you have been paroled into the United States. So you might use that as evidence of parole. Now, one of the big points of distinction that we need to make here is the distinction between humanitarian parole and conditional parole. So conditional parole grants certain individuals parole release from custody that allows them to pursue their case in immigration court in the United States or to provide testimony as a material witness. Now, remember earlier I said that the term parole is used as a catch-all phrase. That's exactly what I'm talking about here. Humanitarian parole and conditional parole are both referred to as forms of parole, but they mean very different things because conditional parole is authorized under an entirely different section of the INA. It's authorized under Section 236A-2B, and it does not grant legal entry into the United States. It grants factual physical entry. It does not grant legal entry. So for the purposes of our training today, we're going to be focusing in on these last two categories, humanitarian parole and conditional parole, to understand a little bit of the distinction between the two and what implications that's going to have for the people that you consult with. So in practice, what do these documents look like? What do the conditional parole documents look like? So conditional parole is documented using an order of release on recognizance. This is a sample. This is what it might look like. And it is Form I-220A issued by CBP. So you can see here at the top, there's the language that says you've been arrested and placed in removal proceedings in accordance with Section 236 of the INA and the applicable provisions of Title 8 of the CFR. You are being released on your own recognizance, provided you comply with the following conditions. So this order of release on recognizance form is how we demonstrate that somebody has conditional parole into the United States. Okay, so somebody comes to your office and they have shown you parole documents. What does this mean for them? So functionally, the significance of having been paroled into the United States really depends on the outcome that your client is seeking and whether or not they are eligible for the outcome that they are seeking. So the next inquiry that we have is this individual in removal proceedings? So if we want to think about removal proceedings, we can talk sort of generally in two broad categories for the purposes of today's training. We can talk about expedited removal under the INA Section 235B1, or sort of what's referred to by the Congressional Research Service as formal removal proceedings under INA Section 240. Now, unless you work at the border, you are unlikely to see as many of you're unlikely to be consulting with folks who are actively in expedited removal proceedings. And if you do see them, it's likely because that individual is in the process of receiving a credible fear assessment. I'm not going to talk about that process right now. It's a bit beyond the scope of the training today, but if you have questions at the end, happy to talk about that a little bit further. Formal removal proceedings under INA Section 240 come with more robust procedural protections, such as the right to judicial review, etc. So your client has these parole documents. They come to you, they're consulting. You need to find out, are they in removal proceedings? And for those of you who don't routinely practice removal defense casework, you may ask, how do I know if my client is even in removal proceedings? Well, we start with some more inquiries. For removal proceedings under INA Section 240, we need to ask, have they been issued a notice to appear? This is Form I-862, an NTA. And if they have been issued that NTA, has that NTA been filed with the immigration court? These are our threshold questions inquiring about whether or not someone is in removal proceedings. Now, non-citizens who are in removal proceedings can have a number of complicated procedural postures that bring them to that place. But this is a good starting point. So from there, what do these documents look like? When we're looking at a notice to appear, an NTA, again, we're looking at Form I-862. This is the charging document. So this charging document contains the factual allegations that support the charge of removability. And so it also states the government's legal basis for charging the respondent as removable from the United States under the INA. So here you can see it in this sample. You've got the factual allegations here, usually numbered 1 through 4, though every once in a while there will be more than that. And then the removability, the grounds of removability, the legal charge that is being levied against your client. Now, the thing that's important to understand about the NTA is that jurisdiction does not vest with the immigration court until the NTA is actually filed. And this was a major issue and the subject of a big class action lawsuit a couple of years ago, because DHS was routinely not filing these with the court after they issued them to individuals. So they were giving the charging document to the individual, but they weren't filing them with the court. So cases were not being initiated and jurisdiction was not vesting. So that's why it's important to confirm when you talk with someone, just because they have a copy of the NTA doesn't mean it was actually filed with the courts. You need to confirm that. You can confirm that by searching that person's A number in an online database, as well as by calling the case status hotline or the pertinent court directly. And I've provided that information here in the slides. So the EOIR automated case information portal, you can follow that link or just Google it online. You can find it very quickly. Or you can call the case status hotline or call the court that's listed as the court of jurisdiction on the NTA, and the clerks there should be able to help you. Okay, so what now? A client comes to you, they have parole documents, and they have an NTA. What does that mean? Well, more questions. What we need to know next is which came first, the parole or the NTA. Because if your client was paroled and then issued a notice to appear, their parole has been canceled. And we find the rule for that in the regulations under 8 CFR 212.5E2I. So if parole came first and then an NTA, the parole has been canceled. However, if your client was issued an NTA and then paroled into the United States, that parole continues until it expires or is terminated. However, that individual will still remain in removal proceedings until those removal proceedings are concluded. Those are parallel processes. Whether or not someone was paroled into the United States is a parallel process, parallel inquiry to their removal proceedings. So from here, we figured out if they have parole documents, if they have an NTA, we figure out which one came first, and then we need to ask, what outcome is my client looking for here? Are they hoping to terminate their removal proceedings? Do they want to apply for some sort of relief from removal, like maybe adjustment of status under the Cuban Adjustment Act, or maybe they want to apply for asylum? And depending on the outcome that they want, the fact that they have been paroled may or may not be relevant. So let's look at some of the common applications of that. When does parole not influence the outcome or eligibility of these forms of relief and removal proceedings? So if you are seeking termination, if you're trying to terminate removal proceedings, a question of termination is a matter of prosecutorial discretion. So that really starts with an inquiry as to whether your client is an enforcement priority. Again, that's beyond the scope of what we're talking about today, but one line of inquiry that you need to consider. Then if your client is interested in applying for asylum or withholding of removal or protection under the Convention Against Torture, those forms of relief don't require parole or admission to be eligible. You don't have to have been admitted, inspected, paroled, nothing. You can apply for those forms of relief without the parole, so the parole functionally really just becomes immaterial in those cases. But there are cases where parole does influence the outcome and the eligibility for relief from removal in these proceedings. And this is particularly for cases involving adjustment of status. So assessing whether parole is sufficient to satisfy a parole, a legal parole, for the purposes of adjustment of status under Section 245A of the INA or the Cuban Adjustment Act is an evolving area of law. So I know that's a mouthful. There's a lot of information to unpack there. Whether parole is sufficient for satisfying a parole for the purposes of adjustment of status under INA 245A or the Cuban Adjustment Act is an evolving area of law. And we're going to deep dive into this just a little bit. I've got a couple of questions coming through on the Q&A. Let me just look at that briefly. So what do I do when a client gets an NTA almost a year ago, but DHS never filed it? What you do about that depends on the outcome that your client is looking for. Happy to talk about that a little bit more at the end in the Q&A. Are there any creative arguments to be made to fight the issuance of an NTA canceling parole? At this point, I'm not familiar with any creative arguments to be worked around that, but I'm sure that there are people who are working on that. In particular, if you want to argue on the timing of the parole or certain types of parole. And then there's another question. Hello, is paroled under 8 CFR 212.5B considered a legal admission for the purpose of adjustment of status? And that's just what we're about to get into. So I'm going to return to the slides here, and I hope that what we're about to talk about answers your question. Okay, so There are two major cases we need to talk about here. And when I say this is an evolving area of law, I mean in real time today, this is an evolving area of law. Because we are starting with a U.S. Supreme Court case in 2018, Jennings v. Rodriguez, and then we are continuing most recently with a decision out of the BIA in September of this year, matter of Cabrera-Fernandez. And we're going to talk a little bit more about each of these. So in Jennings v. Rodriguez, the case focused on sort of broader issues of due process and prolonged detention without hearings. So there's a lot more to the procedural posture of this case and a lot more to the factual development that I'm going to talk about. I'm going to focus in on one really narrow part of this case. So pertinent to our discussion, the Supreme Court found that certain non-citizens, and there are several categories here that are applicable. We're not going to outline each of these categories, but just know there are multiple categories. Certain non-citizens are subject to mandatory detention under INA Section 235B1. So the court started by saying that there are certain people in certain categories that must be detained. And then they also found that the only mechanism for release, if you are subject to mandatory detention, is humanitarian parole. That is the only authority found in the statute for someone to be released from mandatory detention. Now, what's really interesting here is that this point is actually the government's position. This was the argument that was made by the government, that the only mechanism under which they had the authority to release folks subject to mandatory detention was humanitarian parole. So this might seem a little restrictive and sort of like set off some, flags for you of, oh, that's kind of interesting. And there are a lot of advocates who took that direction. It seemed, at least on the issue of parole, to be really promising. So many advocates took the opportunity to argue that folks released from mandatory detention qualified as having been paroled, sufficient for the adjustment of status as a function of law. So this was particularly useful for advocates who represented Cuban nationals in removal proceedings who were seeking adjustment under the Cuban Adjustment Act, right? Because the court was finding that this mechanism, this humanitarian parole, was the only way people could get out of mandatory detention. And humanitarian parole is sufficient for an admission for the purposes of admitted, inspected, or paroled on applications for adjustment of status, right? So this was sort of like a area, I don't want to say it was niche, but there's a very particular category of folks who really benefited from this interpretation until very recently when this issue played out in the case at the BIA. So then the case of matter of Cabrera-Fernandez went before the board. And in that decision, the board reversed an immigration judge's finding that under Jennings, the respondent's release from mandatory detention was a release under humanitarian parole as a function of law. The person was in those expedited removal proceedings that mandated detention. So they were one of the categories of folks who had mandated detention. And so under Jennings, the argument was the only way that person could be released was through the issuance of humanitarian parole. The court here totally walked that back, and they found that the release from detention was not humanitarian parole under INA 212, but it was a conditional parole pursuant to INA 236A2B, such that this person did not qualify as having been paroled into the United States for the purposes of adjustment under the Cuban Adjustment Act. So the decision in matter of Cabrera-Fernandez is very short. It's like 4 pages long, and it has been broadly criticized. It certainly appears to be ripe for appeal at the circuit level. When I was doing some research on this, I wasn't able to find whether that appeal has been filed yet, but we are still within that filing period. And so if it hasn't been, I certainly expect that it will be imminently filed. And there's a lot of really excellent analysis available on this case that gets into it in more detail than we have time to cover today. Particularly, there's a great article from Clinic that I have linked in my resource page at the end of the slideshow. If you're interested in learning more or delving into more of the nuance of this, I would encourage you to take a look there. So keeping this grounded in sort of the practical function for us as advocates, ultimately, what does this mean for my client? It means that to fully assess your client's options, you have to proceed through a huge number of inquiries. There are so many layers of things to consider here. And so this leads to some key takeaways. The first is recognizing that this is an actively evolving area of law. It has changed multiple times in the last couple of years. It seems likely to continue to change. So if you are working with folks who are dealing with the concurrent issues of parole and removal proceedings, you just know going into it, it's going to be complicated and you've got to stay on top of those changes in the law. Knowing specifically what your client's options are requires this inquiry-intensive assessment. You start by asking, was my client detained? Is my client in removal proceedings? What documents does my client have? Were they issued an NTA? Do they have parole documents? If they have those things, which was issued first? And then you also need to ask, what outcome does my client want? And not only is it what they want, but are they even eligible for it? Sometimes folks come to us looking for a certain outcome that they're just not going to be eligible for. So you need to be really clear on those points when advising people what it is worth their time, energy, money to pursue, and what they are actually even as a fact of law going to be eligible to apply for. So that is a very, very bird's eye view, big picture perspective on, as I said, a very complicated and broad topic. If you have further questions to this end, or you're dealing with a certain issue that comes up with some folks that you're consulting with, please always feel free to reach out. You can reach me at the information posted here on the slide. And beyond that, I will open it up to Q&A. There's the resources posted there as well that I mentioned earlier, and should be included in the slideshow that Silke shared with each of you. So I'm going to go ahead and stop sharing. Okay, so going through the questions. Okay, I suppose that it makes the most sense to start at the beginning. So what do I do when a client gets an NTA almost a year ago, but DHS never filed it? It really depends on what you're looking for here. If your client is hoping to apply for asylum, then you are at risk because you've already missed your one-year filing deadline. And so if they wanted to apply for asylum, they should have applied affirmatively with USCIS in the absence of the NTA being filed. So what you would want to do is get that application filed as soon as possible and document any reasons for the delay in that, so that you can overcome inquiries about one-year bar issues that will come up later. If you speak to your client and they don't have a strong application for asylum, maybe your preference would be to get the notice to appear canceled. And that is something that you can request in the exercise of prosecutorial discretion. And how to substantiate a request for prosecutorial discretion, again, is something that's a little bit beyond the scope of what we're talking about today. But there's a lot of good CLE materials out there on that topic. So what you do really depends on what your client's desired outcome is. We touched on the creative arguments to be made to fight the issuance of the NTA. Again, you can make those prosecutorial discretion arguments to try and get DHS to not issue the NTA in the first place. Parole under 8 CFR 212.5b considered legal admission. Again, it depends on the parole itself is going to depend, it's going to depend on what category of parole it was, whether it was a conditional parole or a humanitarian parole. And if that parole has been canceled, what I have been hearing from my colleagues in practice is that if somebody is issued a parole and it is canceled, and then that person tries to seek adjustment of status in court, that DHS has been fighting back hard on that, as saying it's no longer a valid admission for the purposes of adjustment. Now, that seems sort of logically incongruous, because just because an admission or a parole has been canceled doesn't mean it wasn't valid at the time it was issued. So there's maybe some room for pushback on that, but in practice, we're seeing that DHS fights that pretty hard. From Tanja Poe, I have, does anyone have an inquiry intake form, or will page 18 slides suffice? I'm not quite sure I understand on this one. Let me look at what page 18 was. Page 18 was just the humanitarian parole form G56 call-in letter. So just got a case with humanitarian parole yesterday in the call-in letter. So I'm sorry, Tanja, if you can offer some more context there. I'm not sure what you're asking. The inquiry or intake form would be sufficient for what? If you want to provide some context, happy to talk about that further if I'm able to. For Fabiano, does the NTA cancel parole when it's issued or filed? Yes, it does. And that comes from the 8 CFR citation that was provided a little bit earlier. I have a couple of adjustments pending for folks with humanitarian parole from the border. The only evidence of parole that I was able to find was Form I-830 from the USCIS FOIA. Is there a clearer way to find proof of 212D5 parole through the FOIA? CBP and ICE has turned up with no results for me. Typically, Ruth, my best recommendation on that would also be just to start with the FOIA. Some folks have had success in advocating with their local offices for the issuance of clearer documentation. But of course, anytime you interact with ICE officers and are asking them to take a closer look at a case, you are undertaking some degree of risk there and having them give you an answer that you don't want. So you would have to make that assessment based on the record that you have in front of you. Anonymous attendee says, regarding the NTA, my client is seeking asylum. I requested USCIS to assist with the NTA to be filed, but nothing yet. Unfortunately, that's not surprising. We've got folks, especially like I mentioned earlier, the big issue a couple of years ago that led to the class action lawsuit. What we saw just en masse was so many folks whose NTAs were not ever processed with the court. And so all you can do at this point is wait with USCIS, and they may choose to keep the case and to process it themselves. Or if they find the NTA in the record, sometimes a couple years in, we'll get a notice saying, hey, we've received your application and there is an NTA in your file, so we're going to forward your case to the court. And clients are very understandably upset about that, but that is unfortunately just kind of out of our hands. All we can do is be responsive to what's issued by the government. Anonymous attendee, we filed for asylum before the year. I think that's probably in response to the question earlier about what to do if the NTA hasn't been processed with the court. So at that point, you've preserved your client's rights. All you can do is wait. Again, I know that's really frustrating. There's not too much that we can do to advocate for the advancement of that timeline, unless you can, with your local office, get signed up with the short list. That's one way I know people are working with it. But other than that, it's just kind of a waiting game. And what is the significance of NTA terminating parole? Is this relevant to adjusting and whether the person is in lawful status or out of status? So yes, so if the NTA terminates parole, as I mentioned earlier, what we're seeing from DHS is that in practice, they seem to be making the argument that the issuance of the NTA terminating parole means that the person is not paroled sufficient to apply for adjustment of status, which it does not strike me as a particularly logical argument, but that's what we're seeing them argue, at least in San Francisco. For TALA, when someone is charged as arriving on their NTA, does that indicate either humanitarian or conditional parole, hoping that the person has parole sufficient for adjustment of status? So charging someone as arriving is not parole, but if you are an arriving alien, then USCIS has jurisdiction to consider your application for adjustment if you are eligible to adjust otherwise. Confirming from anonymous attendee, minor paroled into the US, but then issued a notice to appear. Proceedings were later terminated. She's not eligible through marriage-based adjustment of status under 245A because parole was canceled by NTA. Is that right? That is a detail-specific inquiry that I don't have an answer for you off the top of my head, anonymous attendee, but if you want to reach out, I'd be happy to be a thought partner to help look into that issue in a little bit greater detail. What is your average caseload and what does the average client seek? Martha, I don't think my caseload is a good indicator of the average, so I'm going to courteously abstain on that one. And most of the clients that I work with are seeking asylum, but it depends on the demographic that you're serving. Some of the attorneys who I know who work extensively with Cubans are doing more Cuban adjustment work. Some folks are doing more family-based petitions, DACA, affirmative, things like that. And then for folks who are in removal proceedings, you're broadly speaking looking at humanitarian relief from removal and possibly like cancellation or other administrative relief, things like administrative closure or termination and dismissal of proceedings, all kinds of different outcomes available just based on what your client is hoping to achieve. Slater Stanley, thank you, Courtney Sloka. Question regarding slide 28 about the importance of timing of receiving parole versus NTA. I'm looking at our defense of asylum clients NTA and I-94 right now, class of admission DT. She entered the US and received her NTA the same day. Does the fact that she entered and was handed the NTA the same day imply that there is no issue about whether her parole was canceled or whether it will continue on? Thank you in advance. So in my experience and discussions with my colleagues on this, Stanley, DHS is probably going to argue that the issuance of the NTA cancels the parole. Unless you can get really specific information as to the time that these were distributed, that the parole was issued subsequent to the NTA. But I know, especially when you're dealing with those border documents, it's not necessarily going to be time-stamped. So I think, but the impact of that and the pertinence of that really just depends on what your client's desired outcome is. If they're seeking asylum in the end, it's not going to be a hugely material issue. From Joshua, Jennings was a pretty ugly case. Can you talk more about who benefited from it? Yes, so totally agreed. And that was, I apologize if I made that unclear. It was an extremely ugly case. It did not hold good things in terms of the due process rights of people who were being detained for long periods of time. The sort of very specifically limited benefit of this was that the holding there was that the only authority that the government had to release people from mandatory detention was humanitarian parole. And so what that did was create this category where especially Cubans, but anyone who was seeking adjustment of status who had been subject to mandatory detention could argue that as a function of law, if they were released, they had been granted humanitarian parole such that they could become eligible for adjustment of status. So it was a very, very narrow benefit, and it is one that the government has now attempted to walk back, but is a subject of ongoing development. Yeah, Tanja, thank you. We'll be happy to follow up with you more afterwards. Ruth, are there recent reports of how USCIS is treating those immediate relative adjustments where the NTA canceled humanitarian parole and then proceedings were dismissed, given that you just said ICE attorneys are fighting these? I'm sure there is information out there on this, but I would suspect, Ruth, that this is a little bit of a moving target, given that this BIA case was just handed down in September. So I don't know that enough time has passed for people to have a ton of insight onto this in practice just yet, but I'm sure that those answers will be emerging. Follow-up questions. If a client was paroled for deferred inspection and then issued an NTA, there's a possibility DHS will push back for the purposes of seeking readjustment. That one, again, is a little bit more detailed than I feel comfortable addressing just off the top of my head. I'd like to think about that question a little bit more slowly. So anonymous attendee, if you would like some thought partnership in researching that issue, please feel free to reach out and we can discuss further afterwards. Do you have any thoughts or suggestions about the possibility of asking the government to extend someone's 212D parole beyond the date on their I-94 or stamp for purposes of obtaining a C-11 work permit? Yes, absolutely. You can always request to have your parole extended. The question of whether or not that will be granted is a separate inquiry, and hopefully you have some strong persuasive arguments of positive equities for your support of your client's request there. I haven't heard any recent anecdotes about how those requests are being treated, but you certainly can request it. Do you know if USCIS is making the same argument? In my case, an I-94 was issued, then a year later, the NTA, and then recently the case was terminated. Now she wants to apply for adjustment of status through a US citizen child. I think I touched on this one briefly. I think this one is a moving target, as these stories and practice experience continues to develop. Hopefully all of you will be sharing your experiences on the listserv so we can get a sense of how that continues to play out. Can you explain the distinction between being classified as arriving and someone who's been paroled? A little bit beyond the scope of what I'm going to talk about today, but I'm happy to provide some follow-up materials on that subject. Anonymous attendee, Afghan was paroled before the NTA was issued. Are judges terminating the case at the master calendar hearing so the Afghan can refile with the asylum office, or are judges setting hearing for contested charge and a contested charge, same as individual hearing? Okay, a couple of different questions there. So are judges terminating the case at the master calendar hearing the termination is going to be a question of prosecutorial discretion. So you need to get the Department of Homeland Security position on termination. If that person is not considered an enforcement priority, it's possible that you will be able to have the case terminated and refile at the asylum office. But in terms of contested charge and contested charge of removability, the NTA cancels the parole. So the charge of removability is probably going to be one that the government stands by. And so you have to then decide if you are going to contest that charge of removability or if you are going to be pursuing relief in some form. A hearing to contest a charge of removability may be calendared as an individual hearing, but that is going to be separate and distinct from a trial where you are litigating a claim for relief. So there might be this initial individual hearing scheduled where you can litigate that claim of whether the person is actually removable or not, and then from there, moving on to the application for relief. Shapur says the significance of being issued parole DT same day as NTA is that the individual can apply for the EAD based on DT. Yes, thank you for clarifying. Okay, I know we kind of blistered through those questions there at the end, and we're just after 1 o'clock. I want to be respectful of everyone's time. Sloka, are there any other questions or anything else we need to cover?
Thank you so much, Courtney. I think someone had asked in the Q&A whether a recording will be shared, and I just wanted to confirm that it will be, and I will send that out within the next few days. And then also just remember to submit that evaluation form once you leave, and you'll receive a link through Zoom tomorrow as well if you for some reason don't get the link right when you leave. Other than that, I don't really have anything. Courtney, thank you so much. I thought that was a very informative presentation. And yeah, also if folks want to get involved with ALRP, like that would be great. Would love to see it. So please reach out about that as well. I think that's everything I've got, and I don't see any more questions. So I think we can wrap things up. Have a great afternoon.
Thank you all.